get out. Get out of this property. Immediately get out. Okay. Get out of this property immediately. Out. I don't want to hear anything. Out of this property immediately. I don't want to hear a word.
Today was another huge win in the Alberta courts for local Calgary pastor Artur Pawlowski. 4 more charges have been tossed out with the support of you at home. Through your generous crowdfunded and tax-deductible donations to Artur's legal fund at saveartur.com. And this is the breakdown.
Right now, of course, you're investing in religious infrastructure, but I think many around the province have a concern that you may not be best protecting their religious freedoms, as we've seen with Pastor Artur Pawlowski. He still remains behind bars. This is well over 30 days. If you could just comment on that situation and maybe perhaps ease some concerns or just give some light to that situation.
So in Canada, we have something called the rule of law, where courts are responsible for adjudicating criminal charges against individuals, not politicians. That individual has all of the rights of any individual under the Canadian legal system. They are presumed presumed innocent until proven guilty, of course, in our system of law.
And so, right now we've yet to lose a case for Artur Pawlowski. We've won every single one that has gotten to trial or gotten up to trial. They either get stayed, withdrawn, or found not guilty, or overturned at appeal. So we've now had 100% success rate to date with Mr. Pawlowski, and we continue to face off with the Crown in February in Lethbridge regarding the Coots charges.
Hey, how's it going, folks? Celine Gallis here with Rebel News. Today, on December 16, 2022, the saga of Artur Pawlowski continues, and this time with another huge win against the unjust pastor-prosecuting government of Alberta. After court was adjourned for the day, defense lawyer Sarah Miller of JSS Barristers joined me to give a more in-depth breakdown of today's court proceedings and Artur's most important court date to come, taking place on February 2nd and 3rd of 2023 in Lethbridge, Alberta. Taking place at the Calgary Court of King's Bench here in Alberta, Artur's charged for allegedly having violated the Calgary Public Health Act on December 13th and 20th of 2020, which was during the time of past Premier of Alberta, Jason Kenney's reign, were finally stayed. Despite Artur's previous charges having been thrown out, the Crown continued its futile charade of trying to cast this man of God in the same carotid artery as actual murderous, thieving criminals. It's been nothing but a massive waste of time and provincial resources from the very beginning. For example, Artur's last charges from earlier this year on October 11, 2022 were also stayed. The charges in question were for one account of trespassing and for failing to wear a mask contrary to the bylaws at the time, all while attempting to pick up his mail from his local Shoppers Drug Mart, and despite his multiple attempts to provide the store staff with his medical exemption, which were both dropped, and was even found not guilty for the alleged cause of disturbance charge. Sarah Millers from JSS Barristers will be joining me today for an interview over Zoom to go more in-depth on Artur's court proceedings, as well as to give an update for his most important court date to come for the very beginning of February on the 1st and 2nd, being held in Lethbridge, Alberta.
Mr. Kenney, we're giving you 48 hours until Saturday noon to get rid of every restriction in our beloved province, because we are free Canadians. If you don't do that, you be very careful, because you have never seen an angry Albertan yet. And I'm again not talking about violence, I'm not talking about swords and guns and all that stuff. You've got the most powerful wings ever, who can move 1,000 trucks or arrest you. Well, here I am. I'm sure there are some spies here. You want to arrest me? I'm not hiding. Arrest me. And from jail I will be yelling and screaming the same message. Canadians, rise up, stand up.
While Pastor Artur Pawlowski took it upon himself to feed the homeless steak, grilled vegetables, and provide hot beverages and other snacks for any passerby to snag, not just the less fortunate, the court system in Alberta continues to allocate seemingly endless amounts of time and resources to prosecuting this pastor instead of allotting those resources to cases where real criminals, like murder and theft, are being brushed under the carpet. Sarah Miller shared her thoughts on the topic. Take a look at what she had to say.
So this morning we were going into day 4, and then Monday would be 5 and Tuesday would be day 6 of a trial related to offenses that were alleged against Mr. Pawlowski arising from December 2020 for supposedly violating the CMOH order that was in effect then. So for Albertans, we may remember December 2020 as a time where we were not supposed to have any private social gatherings. So right before Christmas, they said no private social gatherings. Households could not intermix. Grandparents could not come to visit other family members. Children could not go see their parents if you did not live in the same household, subject to the exception of if you live alone. No intermixing of households. So that was a pretty significant restriction, but it said private social gatherings. So a Christmas gathering with your family, private social for sure. What the Crown has been arguing for almost 2 years now is that when Artur stood on his corner and fed the homeless like he does 3 times a week, that he has done for years, I suspect he will do into the future.
We are providing necessities of life to those that you and your bosses refuse to provide.
Imagine feeding the poor, mentally ill, people that are not allowed, that are barred from shelters is not essential services, but EB games is, liquor stores are, marijuana shops are, Walmart is essential services, but feeding poor, suddenly it's not. I was surrounded by 12 officers. I mean, it was a scary experience, I'm telling you. I've had my runs with the authorities, but they came totally different. They were ready to tackle me down. I was there with my wife. I really thought I'm going to be arrested. And $1,200 ticket was given to me. And I was told, I was threatened that if I ever show up again, more is coming, up to $1 million. Can you imagine?
That was a private social gathering, and that when he attended the Walk for Freedom protest later that month, that was also a private social gathering. We've been saying, of course, that's not private and it's not social. The street church events have a religious component. They are certainly public. Nobody is turning anyone away. And same with the protests. That's a public political gathering, not a private social gathering. Nobody is standing at City Hall in the square there and saying, no, you don't qualify for a protest. That's not private. There's nothing private about it. The court has also agreed with that interpretation. Justice Center for Constitutional Freedoms had a similar question regarding that same Walk for Freedom. Earlier this year in May, they got a completely reasonable result from the provincial court, which said, no, that Walk for Freedom protest is not a private social gathering. Yeah. So that's what we were preparing for. The next 3 days, we are preparing for making that argument. And the Crown this morning stayed the charge. So we've had 2 days reserved for this matter back in February. We did not proceed because the Crown provided very late disclosure the weekend before the trial was supposed to start. So that was adjourned to June. We had 3 full days of trial in June, and that didn't conclude. And so we were adjourned to today. And now, after reserving a total of 8 trial days, we have now been stayed. So charges stayed means that the prosecution has ended. It's come up to an end. There's nothing further, no further court dates, no further anything. Now that said, and it's a certain success, right? If you look at case law regarding whether or not this is a success for the defendant, it is. Yeah. Now, that said, the Crown can exercise its discretion to reinstate the charges and reinstate the prosecution. So it's stayed, not withdrawn. Withdrawn means that they have removed it from the prosecution line. Yeah. Stay means it's kind of like on pause. They could hit the play button again. Now, that said, in practice, it doesn't happen very often once a matter is stayed. Yeah. The other thing that would happen is if this if the Crown pushed play on this one again, we would be in absolute, almost uncontested Jordan area, which means the delay on prosecuting a provincial offense arising from December 2020, we're already 2 years into this, right? Would be so
Goodness.
significant that the first thing we would do if they push play is almost certainly we would bring an application
Yeah.
under Jordan. Now, we were probably at a point now where we could have done that in advance of this trial. It wasn't, it's not never definitive, I guess, but we were certainly looking at it. We believed that there would have been a fight about that, and rather than chase that option, we we really wanted to have a resolution on this based on the merits, based on the statutory analysis. Um, and so we had opted to leave that aside for the time being, not to waive it or anything like that, but just to leave it aside as a side issue and try and wrap this up so that there wasn't any further um, side issues
Yeah.
for this, and just to proceed to the main thing on the merits. So, but if the Crown was to hit play on this, the first thing we would do is bring an application for delay, and that would
Yeah.
almost certainly be successful at this point because the the
How many
delay on this
years?
has
Yeah.
already been substantial, plus whatever delay would happen over the next year. So
Like, what is it from your opinion, as a lawyer, obviously, to be able to have all of these different examples where they're using their time, their resources, taxpayer money to fund these court cases that are for pastors instead of murderous, thieving criminals? What's your take on that?
I have a concern about the use of resources on this trial under the, and not to get into a really complicated statutory analysis, but if you breached a CMOH order in December of 2020, there was two ways the law enforcement and the Crown could proceed against you. The first way is the default mechanism, which means you get a ticket like you do if you're driving down Deerfoot speeding, and it was $1,000. And you had a fine option, you could pay your fine. And I mean, ultimately, there's a reason, a public policy reason why we have that mechanism in place.
Yeah.
It is to try and deter people from spending, launching significant defenses and spending a bunch of their, resources on lawyers and defenses and all of that, because they do a cost benefit analysis and they go, defense, costs, uncertainty at trial, pay my fine, move on with my life, right? These are statutory offenses, right? There's a good reason to just have a fine, allow people to pay it,
Yeah.
accept their fate and move on. Even when they have reasonable defenses, because there's a cost benefit analysis to running a trial. The other way is to proceed by way of summons, which means there is no fine option, which means you must launch a defense, you must run your defense, you must go to trial, you are in the hands of the prosecutor, and the prosecutor can then seek up to $100,000 fine. So Mr. Pawlowski has never been previously convicted of a public health offense. He had, at the time we set the trial date for this offense, he had no other outstanding charges. For whatever reason, law enforcement and the Crown decided, instead of giving him the $1,000 fine option, that they would proceed by way of summons and force his hand into retaining a lawyer, getting disclosure, fighting the offense, defending himself against the offense. And this all requires law enforcement resources, Crown resources, court resources. And what do we hear over and over and over again? Courts are overburdened, understaffed. Crown prosecutors, understaffed, overburdened. Police officers have better things to do and than to sit in court and spend days on end giving evidence about what we weren't disputing.
Yeah.
The video evidence we offered to admit. It's very clear Mr. Pawlowski was on the streets on those days, and that there were more than 0 people in those at those events, right? Our whole defense was, what does private social gathering mean? And the court does not need 3, 4, 5 6 days of trial and argument to determine that. We saw that in May, that it was able to be determined in less than half a day with the
Yeah.
Kerrigan matter and Justice Center for Constitutional Freedoms.
Yeah,
In this
exactly.
case, for whatever reason, we had to have a total of 8 trial days reserved throughout this year, substantial amounts of disclosure, substantial amounts of court resources,
Mhm.
lengthy testimony from the Crown's witnesses, one that was a full day of witness testimony, to describe what was 2 events that we do not dispute occurred, but we do dispute whether or not the CMOH order applied. And that is not an unusual defense or an unheard of defense.
Yeah.
Our blog has posted on what the issues are with this CMOH order, or many of the CMOH orders. They were written poorly for what they were being used to enforce, and that's what it comes down to.
No, definitely. And today, I when we spoke earlier at the courthouse, you made mention of how many different files you've had with Artur Pawlowski in particular, as opposed to all your other clients. Would you be able to touch on that a little bit more? Because I think it really does just speak towards like how heinous this entire process has been.
So I don't know exactly how many files I've had with Artur Pawlowski, but considering he is an individual with no criminal record
Mhm.
and no substantive legal engagement except for bylaw stuff related to street church prior to the pandemic. I've over the past year and a half, coming up on 2 years that I've been his lawyer, I've had more files representing Artur Pawlowski and more hours put towards Artur Pawlowski's files than I have had with any other client. Um, so that's great for all my other clients, but extremely unfortunate for Mr. Pawlowski. And we've yet to we lost before the King's Bench on the contempt, but then of course the Court of Appeal overturned it
Mhm.
in our favor. And so, right now we've yet to lose a case for Artur Pawlowski. We've won every single one that has gotten to trial or gotten up to trial. They either get stayed, withdrawn, or found not guilty, or overturned at appeal. And
Yeah,
so we've now had 100% success rate to date
yeah.
with Mr. Pawlowski. And we continue to face off with the Crown in February in Lethbridge regarding the Coots charges.
Absolutely. And you made very brief mention of it, but I understand it as the very next court case is going to be extremely detrimental in regards to the future and future happenings. Specifically, that I believe that if he's found guilty under these alleged charges from delivering the sermons at the Coots blockade, at the infamous Coots blockade that occurred at the same time as the Ottawa convoy, for those of you that are not aware of that, that he will potentially go to jail and be serving time.
Yeah, I mean, that's been uh, stated, I guess.
Mhm.
Our legal analysis says that on inciting mischief or um, uh, or the Critical Infrastructure Defense Act ticket or offense under the Provincial Act, um, even based on how much time he's already spent in pretrial custody.
Yeah.
I don't have the number necessarily right, but it's around 50 days of pretrial custody. If you get time and a half for that, that means 75 days of pretrial custody that he would have to go towards um, a sentence. And
Yeah.
so if he was found guilty, we expect, based on our correspondence, that the Crown would be seeking custody time. I don't know, they can always change their mind. That's not
Mhm.
necessarily set in stone, but that's what we heard at the bail hearing. And so if that uh, happens, they will probably seek jail time. Our legal analysis is that there's really no basis to
Mhm.
get a sentence of in excess of 75 days for inciting mischief. Can't find a case that supports that position. So always a chance to set new law, I guess, but hopefully that doesn't happen. And we are defending on February 2nd and 3rd there
Yeah.
in Lethbridge to hopefully have no conviction at all, let alone what the sentence might be.
All in all, Alberta's justice system seems keen on condemning Artur, like many other pastors being prosecuted for choosing to have different opinions and serving God and the local citizens of Calgary before stooping to the many fear-imposed unscientific mandates and restrictions during the height of COVID. For Rebel News, this was Celine Gallus. Folks, Artur may have won the battle, but this war isn't over yet. Artur's most important court date to come will be on the 1st and 2nd of February of 2023, where it will be determined if Pastor Artur Pawlowski will be thrown in prison for delivering a sermon to the peaceful protesters, a part of the infamous Coots blockade. Artur needs your help in fighting this unjust legal battle. So go to saveartur.com to donate to his legal defense and to help fight back against pastor prosecuting governments.